The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome to council and also to those who are watching on our Supreme Court live channel. I will ask Mr. Doug Shima, the clerk of the appellate court, to please call this morning's case.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Monday, September 13th, 2021 consists of one case. Appeal number 121765, First Security Bank versus David Buehne and Lindsay Buehne et al., Meade County, briefs both sides. Your Honor, this argument is scheduled for 20 minutes each side. The appellants have reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
Thank you. May it please the court, I'm Zachary Schultz, appearing on behalf of the appellants David and Lindsay Buehne. I'm present and ready for argument.
Your Honor, I'm James Dodge, appearing on behalf of First Security Bank, the appellee. I'm present and ready for argument.
Thank you, counsel. Mr. Schultz, you may begin your argument.
Thank you. This is a mortgage foreclosure case wherein my client obtained a loan from First Security Bank in 2005. In 2006, the bank exercised its rights under the payable on demand feature of the promissory note and called the note, demanding all outstanding principal and interest be paid within 7 days. Then the bank waited nearly 8 years to file suit, well in excess of the applicable 5-year statute of limitations. There are two issues in this appeal. The first is whether the waiver of the statute of limitations contained within the promissory note is void against public policy. If the court decides in the affirmative on that question, then the court must determine when did the statute of limitations begin to run in this case, and was this case filed after the statute of limitations had expired. The statute of limitations, as it relates to written contracts, has been a law of this state nearly unchanged since 1868. Interestingly, that was nearly 17 years before this court first recognized the freedom to contract. To my knowledge, this court has never condoned the complete waiver of the statute of limitations within a written contract. This court's previously held that contractual changes to the statute of limitations cannot violate a strong public policy. Our laws are an expression of the public policy judgments of the legislature. The legislature has saw fit to leave the statute of limitations on written contracts at 5 years since nearly or shortly after statehood. This is a
Counsel, if I might interrupt you, I think this is a good time to ask. There was a statute specifically prohibiting contractual modification of the statute of limitations. That statute was eliminated around 1963 when the Code of Civil Procedure was revamped. What, if any, effect on your arguments does the elimination of that statute have?
Justice Wilson, I don't believe that it has any. There are many good public policy reasons why a party may modify the statute of limitations. For instance, in the case of Barnes versus Gideon, which was cited by the parties were attempting to reach a settlement when the statute of limitations was about to expire. They agreed to extend it until a date certain so they could continue to negotiate the case and try to resolve it without filing suit. Under the prior statute, which was repealed in 1963, that agreement could not have taken place. The parties would have been forced into court. There's strong public policy in support of promoting settlements and parties resolving their claim by agreement. And that statute would have impeded their ability to do so. But I don't think the repeal of that statute implicitly authorized parties to completely do away with the statute of limitations by a written agreement.
Counsel, let me jump in. I think somebody's got YouTube on. You characterize this as a complete waiver of the statute of limitations, and the language of the contract is pretty specific. Actually, what your clients agreed to do was waive any applicable statute of limitations and here's the important part, to the full extent permitted by law. Now, that qualifier, it seems to me, puts any court into the business of trying to decide reasonableness of the time that's elapsed between when the suit was filed and the breach, or maybe the 5-year period. So that's the first part of the question, is do you agree with that? And then second, if it is a reasonableness determination, what's the prejudice to your client between the bank filing at the 5-year mark and the 8-year mark, or whatever it calculates to be?
Justice Biles, I'm going to try to answer your questions in reverse. I don't think that prejudice plays into whether the statute of limitations has run and expired. There's many cases where people are prejudiced or advantaged by the statute of limitations expiring, but those determinations are made by the legislature in setting that time period. I don't think that this is a case where the equitable arguments of waiver or latches or one of those equitable defenses came into play. To answer your first question, to the extent permitted by law, the law in this case is 5 years. And so I don't think that the words at the end of the contract that say to the extent permitted by law expand it past the statutory time frame of 5 years.
Well, then what are you waiving? Sorry for the feedback. What is your client waiving then in that provision under that construction?
Well, I think that our position is that entire provision is void against public policy, because we want to promote the orderly affairs and avoid the litigation of stale claims after witnesses and evidence are no longer available. So whether the exact language of that waiver, in my opinion, is not as important as the public policy of you have 5 years on a written contract to file suit, and you can't extend that indefinitely.
And I understood Justice Biles's question to go to that, whether those public policy concerns were actually in play as a matter of fact in this case.
I don't think that they were, because I'm a little bit hamstrung, because I was the third lawyer hired on this case, and I was hired when summary judgment motion had already been filed. There are certainly facts that could have been developed that may have helped one party or another, but they're simply not in the record in front of us.
Let me ask a question. What if the contract would have said that the parties agree to waive the statute of limitations for 10 years, to change it from the 5 years in the statute to 10 years? Would that have been okay?
Under the holding of Pfeiffer, I think that it would depend on the facts and the reasons that underlie that decision. But I think that's extending it to a time certain for reasons that the parties may agree on is certainly different than stating I completely waive the statute of limitations forever.
Isn't your position, counsel, that a statute of limitations contains aspect of both public policy and procedural personal privilege, that a party has the ability to waive the statute of limitations in pleadings. Isn't that your position, that the statute has both aspects?
The statute certainly contains the strong public policy that claims should not be litigated past a certain time. I think that parties can, the statute of limitations is an affirmative defense that has to be raised by the parties in the litigation, or it can be waived. No different than a lot of the 212B defenses to venue or service. Did I answer your question, Justice? I apologize.
Well, can the provision in the contract be read as only a procedural personal privilege? To give up your right to claim the affirmative defense?
I don't see it that way. I see it as you're completely agreeing that I can file suit at any time to foreclose this loan or sue you to collect the debt.
To Justice Biles' point, are you aware of any case anywhere where a court initially was asked to determine whether or not a waiver was reasonable at the inception of the loan?
Not to my knowledge. I'm not aware of a case that says that this court has said that you cannot waive the statute up front, but I'm also not aware of any case that says that you can. The second part of my argument is, when did the statute of limitations begin to run in this case? And the district court made a factual finding that the subject promissory note was not a payable on demand, despite the note clearly being checked that it was payable on demand. And payable on demand features included in a promissory note containing a set payment schedule are specifically contemplated by the Uniform Commercial Code. And it's important to remember that if you have a set payment schedule, the debtor has to pay according to the payment schedule. And the lender could not file suit until each payment had been missed. Commercial notes often have an acceleration clause that say, upon default, the bank can accelerate the note and all principal and interest would be due. Then the lender can further expand their rights by making a note containing a payment schedule payable on demand. So they don't even have to wait for a default. They simply have to make demand. And the party, the debtor, has to comply with the demand.
Counsel, you agreed that your client was in default, correct?
Yes. Yes.
And is it your position that after default, the bank specifically accelerated the loan?
I would not use the term acceleration. I would say that they made demand and called the note under the payable on demand features of the note.
For the entirety of the amount loaned, right?
Yes, the demand letter sent by the bank specifically said that all outstanding principal and interest are due and payable within 7 days, which it had the right to do under the payable on demand feature of the note. After my client failed to comply with the demand, the bank had the right to send demand. My client had a duty to comply with that demand. And when they failed, they had defaulted on their duty to comply with the demand, and the bank could have filed suit. And that was in 2006. This case was not filed until 2014.
Counsel,
Is it, go ahead.
on the notices, the demand for all outstanding balances due and owing, why is that not a reference just to the accrued installments that had lapsed to date?
Well, if they wanted to say that, they could have said that demand is due for all the payments that have been missed. But when the bank states that all outstanding principal and interest, the entire loan was outstanding. All the monies loaned by the bank were outstanding.
Do you think the bank was required also to do another step that indicated enforcement of the demand?
I do not believe so. Once there had been a right, a duty, and a default, the bank had the right to file suit. And there are some cases that talk about acceleration, which is where the district court erred and the Court of Appeals failed to decide that issue, where the district court stated that the statute of limitations didn't begin to run until the bank took actions to enforce their loan, and they didn't take action to enforce the loan until 2014 when they hired an attorney. But that's really an untenable position in the law that your statute of limitations wouldn't begin to run until you hire an attorney. They would just completely do away with statute of limitations absent somebody committing legal malpractice and waiting more than 5 years to file suit.
Did the bank do anything earlier to indicate they were enforcing the loan? Their intent to enforce?
Not to my knowledge. They sent demand, and they sent a follow-up demand stating that you have not failed to comply with our demand. We're turning this over to our attorneys. I believe that their system continued to generate notices that went to my clients, but they never took action, never filed suit until 2014. But the case that the district court relied on was a consumer mortgage, and it had the Fannie Mae, Freddie Mac consumer protection clauses in the acceleration clause, and they required notice to the debtors that the loan was being accelerated, had certain right of time to cure, and other consumer protections that are mandated by mortgages. They're going to be resold on the secondary market. That's completely different analysis than the bank exercising its rights under the payable on demand feature of a commercial note. So I don't think the action to take enforcement applies in this case. It's rather the general legal principle that when you have a right to file suit and you have a right to enforce your claim, that starts with statute of limitations, and you have a duty to do it within the time mandated by the legislature.
In November of 2006, the bank sent a letter that says, we have no alternative but to send this to collections. Did that have any legal effect?
Justice, I want to make sure I can answer your question here because my time is up. Can I proceed? Thank you. I don't think it did. That those additional demands are superfluous at that point because the bank already had the right to file suit. If the bank had filed suit 10 days after they sent their 7-day demand letter, there is no way that my clients could have got that case dismissed by saying the bank didn't have the right to file suit at that point. And if they had the right to file suit, then they certainly had the duty to do so within the statute of limitations.
Are there other questions? Thank you, Mr. Schultz.
Thank you.
Mr. Dodge?
Thank you, Your Honor. in addressing the issues before the court, I think the court's first needs to address the factors of the contract. These don't occur in vacuums. That the terms, the top of the document, it states commercial note. That this was an agreement for a loan of $323,000. That collateral that had been pledged to this project involved real estate, involved car wash equipment, that this note had specific payment terms in it, despite what the appellee would like to believe, that it starts that a month after the inception of the note, which began in June of 2005, that a month later, the first of 4 interest-only payments were to begin. And then after that, those first 4 months, then payments of approximately $2,300, 240 payments of $2,000+ were to be paid. Now, there is no payment must be made on a particular date in this note. You won't find it anywhere in the agreement, but you'll also note that this is a closed-end note. This wasn't a revolving line of credit. This would be a one-time deal. That these funds were not just obtained for this one project to build a car wash on the outskirts of Meade, Kansas, but there was also another note involved in this lawsuit that was involving the construction of a car wash in Liberal, Kansas. So taking into account, this is nearly $1 million project. And so the court, I think, needs to, in evaluating the reasonableness of the waiver of statute of limitations, needs to consider that this is a commercial project, that lots of money was involved, that it would take a while, I believe, Judge, for payments to be made. And this loan recognized that. The last payment due on this note, according to the contract, to the promissory note, was in 2025. So if nothing had been done by First Security Bank, if they had just still sat on their hands, if they hadn't sent any letter, the maturity date on this note is still 4 years in the future.
Counsel?
Yes.
Parties can't waive public policy, can they?
I don't believe that necessarily can waive public policy, Judge. No, the court has, they may try to, but I think their success at court might be severely limited if they try to do so.
Do you agree that the statute of limitations contains components of both public policy and personal privilege, procedural personal privilege?
Yeah, Judge, I do. I believe that their statute of limitations, I think the phrase that I like, are ones of necessity, in the sense that the court has an interest, the public has an interest in claims being settled timely, that we don't want lawsuits brought after witnesses have disappeared, after memories have faded, after parties maybe have changed their positions and thinking that something had been settled, and then now it's brought up again. There's a convenience for the court not to have to deal with those claims. I think there's a public policy aspect of it, in that we want to have suits timely brought, and that we need to be able to address those things in a timely fashion. So I hope that answers your question, Justice Wilson, in the sense that I think it does contain both aspects of procedural personal responsibility and then also public policy.
I'll ask you the question. Yes, I'll ask you the question I asked your opposing counsel. The statute that prohibited contractual modification of the statute of limitations was eliminated when the Code of Civil Procedure was revamped in 1963. Does that eliminated statute have any effect on your position?
Well, I think it goes to how strong public policy this issue actually is.
Why?
Back when that statute was in place, I mean, the language of that statute says those contracts, those agreements to extend a limitations period beyond what's contained in the act are null and void. They were dead from the beginning.
Are you aware of any legislative history where that was specifically addressed and your argument was made?
No, Your Honor.
Counsel, what does that phrase mean in your loan agreement that they agree to waive the statute of limitations to the full extent permitted by law? What meaning are we supposed to give that?
Well, Judge, if the First Security Bank would have come in and said, hey, this was a fraudulent loan, that for whatever reason, they could have argued fraud, they could have argued illegality. They could have argued that, hey, this was done under duress, that those type of arguments are still present. If the bank had failed to do their job, if the bank had failed to timely provide the money, for example, and it caused them harm, they would be able, I think, Judge, to go ahead and proceed on those claims, or maybe invalidate how those things came about. It still allows those claims to be brought. Those basic contractual rights that if they would claim, hey, we didn't know we entered into this by mistake, we didn't know this term was in here, those things could still be brought.
So your intent, I'm sorry, go ahead, Justice.
I'm just going to say, you go on to, in that sentence, to say, and this would be the lender, the borrower would waive any right I may otherwise have to require the lender to proceed against any person or security before suing me to collect this. I mean, it seems like you read those two together, it seems like it has the meaning that the borrowers are trying to give it, that it is in effect, just killing any statute of limitations defense, or anything else that may require the lender to proceed.
Well, Justice Biles, if you even go even further to the beginning of that provision, it talks about failure to exercise the right or enforce a provision under this agreement is not to be considered a waiver of all time to present those arguments later. I think if you can read it within the whole context of the promissory note, understanding that, Judge, even if you go to when interest-only payments are due, there's no schedule about when that can happen. It's entirely possible that when we get towards the end of the note that the lender, or excuse me, the borrower could have made 240 individual payments and still been in compliance with the note. And so I think in the context of a commercial note, that those provisions allow some flexibility, that if a lender misses or borrower misses a payment, but the bank's not required them to automatically start sending letters, where they can work with the lender. I think it actually works. Sometimes these things work to the advantage of the borrower as well, and that it doesn't require, all of a sudden rushing to the courthouse.
Is the full extent of that provision to mean that the bank could wait 20 years to file a lawsuit?
Well, I mean, Justice Biles, the note itself has a maturity date of 2025. So that's one part of it. But I think there's also there's a latches doctrine that could apply as well. I mean, I think the borrower could have said, hey, an argument of latches means that this thing should have already been resolved, and they're an equity argument. So that argument would still be available to them.
But under the contract provision, you agree that it is complete and unlimited, right?
It's only limited by the phraseology of to the extent allowed by law.
But what meaning does that have? What meaning do you think, you claim that it has?
Well, just like we talked about with Justice Biles, I think there could be an argument of latches, that if the bank had waited 20 years past and that all the people that were involved in this case were gone, there would be a definite latches case, defense available.
But that's latches. That's not the statute of limitations. Your intent was to completely kill the statute, right?
It was to allow the parties to complete this loan without the requirement of dealing with the statute of limitations.
Was the loan accelerated in October of 2006 to the full extent of the loan?
No. It's our position, Judge, that because of the features of this note, the optional acceleration clause, two things would be required. First is there has to be a clear and unequivocal exercising of that option. A statement of some kind saying we are exercising our rights under the acceleration clause for the full amount of the loan plus interest, and here it is. That never happened in any of the 32 plus letters that were sent by the bank. At no point will you find in any of those letters a principal amount balance asked for or claimed for. It just simple statement of it's now due. And going back to the FGB case, there was a citation that simple statements of all is now due is not enough to exercise or to bring into effect the acceleration clause. Where the
What effect, if any, did the statement, "We have no alternative but to turn this over to our attorney for collections"? What did that have?
I don't think it had anything to do with it. I think what they were telling the borrower was, we don't have any other choice. We've tried to work this out with you now. We're moving forward. We need to move forward. Because it's an optional acceleration clause, there needs to be some sort of overt action to try and use that acceleration clause. And I guess that's what I would say. An example would be if the bank tried to exercise maybe a right to set off, or that if the bank had gone and seized some collateral in this case, none of which happened, that would be that second step. These letters, as you can see, are computer generated. And so these were attempts, I believe, to get payment going. At no point in any of those notes do you see a demand for $323,000.
So can you help me understand, Mr. Dodge, what your position on whether or not this is a payable on demand note? Would you agree with that?
I don't believe it's a payable on demand note because of the optional acceleration clause provision. That once a typical payable on demand note, you hand the note to the person, say, pay up. It's time that this gets paid. And you have a right to amend it. But with that optional acceleration clause, that provision doesn't necessarily apply. It allows the bank to say, hey, this full amount's due. And there might be conditions where that would be relevant, such as, maybe one of the parties had passed away, or both parties had passed away who were involved, or that maybe someone filed bankruptcy, they weren't currently in default of their note, but their situations had arisen. Those sorts of things might trigger that payable on death feature. But in this case, it's that optional acceleration clause that I think is relevant. And that's what determines when the statute of limitations, or when the clock starts ticking.
Except for potentially the individual installments that were due on the note, correct?
Oh, you're right. And the individual installments, going back to the term of the note, the first one is due, I believe it says July 28, 2005, for interest-only payments. That's when the first one's due. It doesn't say when the others are due. And then it talks about the payment of principal.
Well, you know where the first one's due, right?
Right.
July 28th,
Right.
Or November, I'm sorry, 28th. Monthly payments.
The monthly payments are due in November.
Right. And it's for 240 installments, and that's 20 years, and the maturity date is also 20 years later. So reading those provisions together, I think, don't you think we do know when those installments are due?
Well, I think we know when the first payment of interest only is due, and we know when the first payment of the principal payments are due. After that, I think the contract gives enough flexibility to the borrower that he can maybe miss a couple months in payments and still be not in default, because the contract itself doesn't say, payments are due on the 5th and they're considered late if received thereafter.
And can you help me then on the 2006 notices? There's a phrase that the bank uses. I'm quoting, "It is necessary for you to pay the loan in full or renegotiate a new loan." Why is that not a notice of acceleration?
Because it doesn't clearly and unequivocally state that now we're increasing interest payments. It doesn't state that now we're going to exercise a right to collateral on all those other type of obligations. I think it's an invitation to renegotiate the note, or an invitation to continue a discussion about making a payment.
to pay the loan in full
To
or
possibly-
renegotiate.
Or renegotiate, yes. One of the issues I'd like to address in my time that's left is there's been a presumption that the statute of limitations is a strongly held public policy. And I don't believe that it's a strongly held public policy to the extent that we can never waive it. If it were a strongly held public policy, then how can we waive statute of limitations by accident, such as we don't raise it as an affirmative defense? It's not a jurisdictional requirement. We don't require parties allege that an action occurred within the statute of limitations in order to bring suit. And so there are various provisions where this court has said that the statute of limitations I believe it can be waived. It's a contract through a contract. And we've had issues where the Younger case that was cited, where in the will, there was an extension of time that extended the statute of limitations. And then in the Barnes case, where we extended the statute of limitations so the parties can continue negotiating. Going back to the previous statute that Justice Wilson referred to, those agreements would have been out because the law says any agreement at that time said any agreement would be null and void. So I don't think that the statute of limitations are a strongly held public policy. I would say, though, judges, that this court has been reluctant to shorten the statute of limitations. Going to the Pfeiffer case, where limited on that facts, the court found that shortening the statute of limitations would have a chilling effect on the Kansas Workers' Compensation Act, which there was strong public policy favoring resolution of worker injuries through the Workers' Compensation Act.
Is there any difference? You cited the Younger case and you cited in your brief the Barnes case. Is there any difference in your mind in the fact that those negotiations were done after there had already been a default, as opposed to your situation where it was at the inception of the loan? There had not yet been a default. Is there any difference that would distinguish those cases in your mind, or is that inconsequential?
Well, obviously, that the consideration argument element would be one of the differences. But in this case, too, consideration could also be involved with waiving it prospectively, that the terms of the notes, how long the note is, those also could be considered valuable. In looking at freedom to contract, the court should presume that these contracts are valid. In involving two commercial parties, the court should presume that both parties, on these terms that were negotiated, there was consideration, there was give and take. That there's been no argument made by any party that this was an adhesion contract, that this was snuck in at the 11th hour, those sorts of things. So in like the Younger case, where there was a note that if it hadn't been paid by the time the decedent passed away, then we would continue it, but he also then waived his right to a spousal share. In the Barnes case, we knew that there was litigation pending and deadlines were coming up, and both parties wanted that extra time to try and negotiate.
So your argument is that you had consideration in your case for the waiver of the statute of limitations, including the public policy aspect?
That part was never litigated at the beginning of the case, and like Mr. Schultz had indicated, I came into this case at the 7 or 8 year mark after the letters were sent. So I can't say with any honesty, Judge, that was a specifically negotiated term. I just know that commercial lending agreements or commercial contracts, both parties have an obligation to read. Both parties had freedom to walk away if they wanted to, and that never happened.
Mr. Dodge, I have a question, just going back to that you don't think that there's a strongly held public policy. This court in 2011 in Campbell versus Husky Hogs laid out 3 situations to determine whether or not a strongly held public policy exists. One is that the legislature has clearly declared the state's public policy. The legislature enacted statutory provisions from which public policy may reasonably implied, even if it's not directly declared, and the legislature has neither made a clear statement of public policy nor can it be reasonably implied. Is it your position that it's number 3? The legislature has not made a clear statement of public policy, nor can it be reasonably implied?
Well, yeah, I guess the answer is, in a sense, yes. There is not the previous statute that we talked about that was repealed. It clearly
I'm talking about the statute of limitation statute.
right.
Is currently in place and was in place at the time the contract here was signed.
And none of the provisions in that statute say that these limitation periods are inviolate. It doesn't mean that the parties can't. There's nothing in there that says agreements to modify that can't be entered into. Kind of taking the provision from, if it's not.
I'm just talking about, you said that there's no evidence that the statute of limitations is a strongly held public policy by our legislature. But isn't the fact that we have statute of limitation statutes clear that the legislature has clearly declared the state's public policy, which is the number 1 situation, and when we in Campbell versus Husky Hall?
Well, when you do have a statute of limitations, the court has declared, or the legislature has declared, that actions brought under contract need to be brought within 5 years. That's the statement. But under the Kansas Pacific Railway case, the court, there's no, we don't have any well-settled precedents determining that this can't be extended. We've got several cases which say we shouldn't shorten them, the statute of limitations period. But there's nothing that says that the parties can't extend them. So I would say the public policy in this case of the state of Kansas is contracts should be no less than 5 years. Bringing those actions should be no less than 5 years, unless there's, if it violates some strongly held public policy, such as in the Pfeiffer case. The court kind of indicated that there might be situations where we could shorten that statute of limitations. That Pfeiffer case was limited strictly to that certified question of whether or not there was a public policy against that employment agreement, and in which case the court found yes, there was.
Thank you.
And I believe I'm out of time.
I see no other questions. Thank you, Mr. Dodge. Mr. Schultz, you're reserved 3 minutes.
Thank you, Madam Chief Justice. I'd like to wrap up my argument by focusing on the big picture ramifications of this case, which are, if this court says that contractual statute of limitations waiver provisions are okay, then either this court has to get into the public policy making arena of deciding, do that apply to consumer transactions, commercial transactions, neither, both? There was a question about, well, if this is allowed to stand, is 20 years too long? Is 12 years too long? Is 8 years too long? Those determinations are best made by the legislature, and that those laws have been on the books since 1868. There are certainly many instances in which I can imagine businesses, especially those extending credit, using waivers of the statute of limitations in everyday transactions. The dentist, the car repairman. I work across the street from the hospital, and we all know how fun medical billing is and how many times things get lost. The statute of limitations are there, so after a period of time, people can move on. They don't have to worry. They don't have that liability.
Before you run out of time, I have a similar big picture question as you put it. We let individuals who have their liberty interests at risk waive constitutional rights all the time. Waive their Fourth Amendment right to search and seizure, waive their Fifth Amendment right to self-incrimination, Sixth Amendment rights to jury trial, all of those things which I think we could all agree are some of the most deeply embedded public policies in our society, can be waived. So why wouldn't we let what I again think would be pretty non-controversial to say is a lower order interest, a statute of limitations? Why wouldn't we let that also be waived?
I think that, to use your analogy, this would be like saying, if you drive a car, you waive your Fourth Amendment right to be protected against unreasonable searches and seizures. After you're pulled over, you could waive that by your actions, and there are competing public policy provisions of protecting society and reducing crime. But we don't say that by getting in a car, you waive your Fourth Amendment rights. By all sorts of instances where maybe there's specific facts and judgments where those are waived, but we don't condone carte blanche waivers up front in the beginning. I see
Any other
that.
questions? Sorry, Mr. Schultz. Go ahead and conclude.
I was just going to note that I was out of time, and thank you all for your time. We would ask that the court reverse the Court of Appeals and reverse the district court, find that the statute of limitations waiver was void against public policy, that the bank waited too long to file suit outside the statute of limitations, and direct the entry of judgment for the defendants. Thank you.
Thank you to both counsel for your arguments. I'll repeat that because I had some feedback. Thank you, counsel, for your arguments today. The court will take this appeal under advisement. We are now in recess until